Agreements are the heart of your business. And indeed, your entire business is one vast series of agreements. Agreements with investors and lenders, clients and vendors, employees and contractors, as well as partners and customers. Yet, despite the critical role they play in a company's success, far too many business owners fail to take their agreements seriously. Hi everyone, my name is Becky Easton, and this is the podcast Family Wealth and Other Musings. I'm so glad you've come back to join me here today, and if you're here for the first time, welcome. Today is Work It Wednesday, so we are talking business. Today it's about 10 pitfalls to avoid with your company's legal agreements. This is going to be another two-parter, guys. We'll talk about the first part of this list today, and then we'll come back next Wednesday to talk about the remaining portion of it. And I want to mention a couple things that, of course, this is not legal advice for you. I don't know what your specific situation is, so this is just conversation and information for your knowledge. And if something makes your ears perk up, then I definitely encourage you to reach out to an attorney, a personal family lawyer, or a family business lawyer near you. When it comes to business matters, you can find a family business lawyer near you by going to familybusinesslawyer.co. That's just CO at the end. So, what pitfalls are there to avoid when it comes to your company's legal agreements? Whether it's winging it by creating your own agreements or using cheap DIY legal documents you purchased online, failing to treat your legal agreements with the respect they deserve can cost you significantly. And in fact, just one poorly constructed agreement could end up costing you tens of thousands of dollars in attorney's fees and court costs, or even put you out of business entirely. And given this potential risk, having an experienced business lawyer prepare or at least review your agreements is absolutely essential in protecting you and your business. So, to demonstrate how complex legal agreements can be and how ill-prepared you are to draft on your own, here are 10 pitfalls that can put your company in serious jeopardy if you take the DIY route with such important legal documents. So number one pitfall is not using any legally documented agreements at all. So agreements can actually be created verbally without any written agreement at all. And whether you think you can go without legally documented agreements because you only do business with people you trust, or because you think agreements are something only big companies need, or because you think agreements are simply a way for lawyers to make money, you're setting yourself up for major costs down the road. Such beliefs are a serious misunderstanding of the role legally documented agreements play in your business. In reality, your agreements are among your company's most crucial tools, and these tools offer your company more than just legal protection. Agreements don't just protect your assets, they give your relationships the greatest chance of success. They protect your intellectual property, your time, your energy, and your attention. And they let you know upfront whether or not you're going to want to work with a particular vendor, client, or partner. For example, documented agreements force both parties to work through important issues and potential sticking points inherent to the success of the relationship before any work begins. This not only saves time and money by preventing unnecessary future litigation to unwind a relationship, but it gives you early insight into how well you and the other party deal with conflicting viewpoints and desires, which is a vital part of any relationship. Ultimately, having well-drafted legal agreements can enhance just about every aspect of your business, whether it's boosting revenue, expanding your operation, hiring the most talented team, or improving your relationships, and you simply cannot afford to go without these crucial legal documents. Number 2, signing without reading or understanding an agreement. Every agreement you enter into is likely to contain complex terms and legal jargon that can be tedious to read all the way through. But it's vital that you not only read, but fully understand all of an agreement's terms before you sign, since these terms can have a major impact on both you and your business if and when you ever have to go to court to enforce the agreement. Before you sign any agreement, you should have a skilled attorney with family business planning experience review the agreement with you to ensure you completely understand exactly what you're agreeing to and the full implications of your agreement. And be sure to seek counsel before you sign, because once you sign, it's too late. You've already entered into an agreement and are legally bound by its terms, regardless of whether you understood them or not. Number 3, failure to include or negotiate key terms. One of the biggest mistakes you can make when entering into an agreement is letting the other party convince you that a key term or clause doesn't need to be included because it's something that's assumed, unnecessary, or that a key term is just standard. In legal agreements, there are no standard terms or terms that are assumed or unnecessary. If you have an agreement and it's not written into the terms of a legally documented agreement that you have signed, that term will not stand as a term of the agreement if later on you ever need to enforce that agreement. Moreover, all terms in an agreement are negotiable. In addition to helping ensure you fully understand an agreement's terms, making sure your agreements include the necessary terms is another area where an experienced business lawyer can provide invaluable insight. To this end, you should have trusted legal counsel review every agreement before you sign. Make sure that all of the necessary terms have been included and that those terms are documented clearly enough that anyone could understand them. Number 4, failure to establish a clear performance standard. It's fairly easy to enforce an agreement with a vendor who doesn't pay or a contractor who misses a deadline. The facts are clear in these situations. However, things get trickier when it comes to more subjective areas of the agreement, such as poor performance or for-cause termination. To address this, your agreements must be as specific as possible about the goals, objectives, and deliverables of the relationship to ensure your vendors, employees, and contractors are clear on what success looks like, and that those success terms are outlined within the agreement. If not, you may get stuck with a shoddy product or a poorly performing team member, while still being required to pay for the work. When you hire a new employee, for example, you should establish clear, measurable outcomes for the role, with specific metrics for success, along with timeframes for specific goals and objectives to be achieved. Then, include this information in the employment agreement, so it's abundantly clear what the expectations for the position are, and for the team member, and for you. Number 5 is not defining what constitutes a breach. Along with establishing clear expectations for performance, it's also vital to consider all of the things that can go wrong in a business relationship before work even starts, and then establish a clear process for addressing each issue in the agreement. For example, in the prior scenario, you need to think about how you deal with the new team member if things didn't work out as expected. What would happen if the individual needs to leave, can't perform, or isn't performing for some reason? What is each of you entitled to in the event that the relationship needs to end? All of these scenarios need to be thought out thoroughly and clearly addressed in the agreement. So next week, when I come back to bring you the remaining 5 pitfalls to avoid with your company's legal agreements, I hope you will join me again to learn more. And for now, though, I hope you'll make the commitment to never sign another legal agreement until it's been reviewed by an attorney, and preferably someone with that family business planning experience. This is a wise and invaluable practice for your business, and one that I can I'll honestly say I like to support every client with. Whether you have existing agreements that need to be reviewed or you need new agreements drafted, a good attorney is going to be there for you. And enlisting their support with your agreements could be the make it or break it difference for your business. So head over to familybusinesslawyer.co to find a family business lawyer near you. And if you're in Arizona or Colorado and find that this is something that you'd like to discuss more with me and my law firm, I am a personal family lawyer licensed in both of those states, and you can find some time on my calendar by going to bit.ly/call Easton Law. And I want to thank you again for being here with me today. I will be back tomorrow with some new content for you that I hope you will enjoy on this journey to post an episode every single day. In the 80s now, guys, it's very impressive. At least coming from my end, I think it is. So I am your host, Becky Easton. This has been the podcast Family Wealth and Other Musings, and I am so glad you joined me today. I will talk to you tomorrow. Have a great one.